All right. Well, it's about one past the top of the hour, at least where I am. So I think we're going to get started. Good afternoon, everyone. Thank you very much for joining us today for our panel discussion entitled Beware and Be Ready: How Employers Should Prepare for Evolving Immigration-Related Issues under the Trump administration. We really hope that this panel discussion today will be informative on all I can say is the evolving issue of immigration and employment immigration facing employers in today's business environment. My name is Jason Tremblay. I'm a partner and vice chair of the firm's Labor and Employment Practices Group. I'm based out of Chicago, Illinois, and I'm joined by three of my esteemed colleagues who are helping me with this presentation today. So from East Coast to West Coast, start off by introducing Cynthia Gomez. She's a partner in Saul Ewing's Global Immigration and Foreign Investment Group. She's based out of our Washington, D.C. office. Also joining me from the Chicago office is my partner, also in the Labor and Employment Group, Alex Rich. And finally, last but not least, I'm joined by my partner, Terry Tracy. She is also a partner in the Labor and Employment Group, and she's based out of our Los Angeles, California office. So there has not been a topic or issue that has received more attention, right? Socially, politically, economically, and of course, legally, than immigration. It seems like every day I turn on the computer, there is another executive order on immigration. There's litigation that arises from that. So we really do appreciate the opportunity to spend an hour or so with us, providing some insights and best practices from some of our firm's immigration employment law experts. But before we dive into the meat of the program, of course, I'm going to have to go through some housekeeping matters. So first of all, questions. Questions can be submitted through the Q&A tool that is at the bottom of your screen. While we'll do our best to answer all those questions during our webinar, and I think we'll probably answer many of your questions during the webinar, should we run out of time, we only have an hour, we will follow up individually by email as soon as we can. Of course, CLE. This program is eligible for one distance learning substantive CLE credit in a host of states. In order to verify your participation and receive the credit, you'll need to complete a brief continuing legal education survey and note the numeric codes that I will be providing to you orally in today's webinar. I think they'll also be placed in the chat. These codes, as you know, are part of our requirement to get CLE credit. The verification survey link that I referenced before, that was included in your reminder email, and it's also linked to the resources tab that's found at the bottom of your Zoom screen. So make sure that, I believe you have 5 days, but make sure to complete the survey within that time period to get your CLE credit. As you can see that this webinar is being recorded, and so in the next few days, you'll receive a follow-up email that will include links to the webinar recording, supplemental presentation materials, and CLE information. Because this is a panel discussion, we're not going to have a traditional PowerPoint that we go through during today's program. However, our PowerPoint and substantive written content, which is probably more extensive than what we'll actually have time to talk about today, is available within the resources tab of today's webinar. And last but not least, we have to do the legal disclaimer. My apologies, but the provision and receipt of the information in this program is one, not legal advice. It does not create a lawyer-client relationship, and certainly should not be acted on without seeking professional counsel who've been informed on the specific facts of your situation. And I want to emphasize that even more with the topic we're discussing, because it's changing almost daily. All right, so with that, let's begin. And Cynthia, I'm going to start off with you. And I want to do some level setting. Can you give us a brief summary of the primary immigration laws impacting employers? And I want to distinguish those from the topic we'll talk about later, which is the recent executive order. So what are they?
Sure. Thank you, Jason. I think this adds a really nice foundation to our discussion. There are lots of laws, but we're going to focus on two primary statutes. The first one is the Immigration and Nationality Act, also known as the INA, which was enacted in 1952, and it's been amended numerous times over the years. But it's essentially the foundation of federal immigration law. It governs all areas of immigration and citizenship, and essentially governs anyone who is applying for a visa, immigrant or non-immigrant, so temporary or permanent, including those that are in the employment-based categories, like for employers such as H-1Bs, L-1s, O-1s, EB-1s, EB-2s. Those are ones you've probably heard of. And it also really provides the authority for the various federal agencies such as Department of Homeland Security, Department of Justice, Department of State, and Department of Labor to enforce and really administer the immigration system. That's the INA. Then there's the Immigration Reform and Control Act, IRCA, which was enacted in 1986. And this is what we're seeing a lot of, anything that has to do with enforcement and compliance. That's like what set the foundation for that. So it really shaped that whole component of immigration. And so some of the components of IRCA that we see today have to do with employer sanctions, right? So I-9, and so this was the first time that it became unlawful for employers to knowingly hire individuals who were not authorized to work. So it established the requirement for I-9 for employers to verify the identity and work authorization status of their employees. And so, and also made employers subject to civil and criminal penalties if you don't comply. Yeah, so and then essentially with that, right, there's anti-discrimination provisions as well, that essentially, require employers to be careful not to discriminate based on citizenship or national origin. And that's enforced by the Department of Justice, the Civil Rights Division specifically. And then, as we know, like I mentioned earlier, so IRCA laid the foundation for the modern like employer compliance programs that we see today, like I-9, E-Verify, and then the audits that we're seeing by ICE and the Department of Justice.
Right. Those are all issues I think we're gonna come into our conversation today. So I appreciate that kind of level setting. I got one more for you though, and I think that's one of the reasons why we're talking about this issue and why it's important. But kind of distinguishing from the existing baseline immigration laws that apply to employers. I guess as it sits today, can you briefly kind of outline what the primary immigration related executive orders at play that are impacting employers? Again, I know there's a lot of them, and I think some of them are in our materials, but could you take 3-4 minutes just to talk a little bit about what are the more important ones that are impacting employers today?
Sure, I'm going to really focus on two of them that have lots of different impacts. So I'll do my best to summarize. The first one has to do with Executive Order number 14161, protecting the United States from foreign terrorists and other national security and public safety threats. So this specifically orders the Department of State and the Department of Homeland Security to implement strict vetting, right? For anyone who's applying for a visa, whether you're inside the US or outside the US. Obviously, the direct impact to that is, you're going to have delays, right? There are going to be delays with processing, which impacts planning, right, for your staff, right? Looking at who needs to extend their status? How quickly do I need to act on this? Is it a good time to send this individual outside of the country or not, right? These are some of the questions that are going to come up and the challenge that this kind of provides for employers. And so because it orders all agencies to implement this stricter vetting, it's not just delays at the consulate, it's also in the US. So that's just something to keep in mind. With that, there will also be something called more administrative processing, meaning there may be delays that are outside of our control, like where there's little we can do. So it's not just that there is a delay to get an appointment, but rather a delay because of a security clearance issue or Something else where unfortunately we won't have as much power to investigate why did this happen or not. And so just, the tip for that is planning ahead and ensuring that we're taking a look at your master immigration org chart, if you will, and identifying where we need to act quickly to avoid some of these delays. That's the major, I guess, impact for employers in that regard for that particular executive order. The executive order number 14159, protecting the American people against invasion. This one's very broad. But essentially, this is what set new enforcement policies to address unlawful presence and really remove anyone who's in the US unlawfully. So what we've heard on the news, what everyone has heard of, and really the title of this webinar, in immigration enforcement. So the raids, I-9 audits, right? So this is kind of what's triggering that, more of that, and what we're seeing across the country. What else? And we'll talk about this later in the presentation, but the phasing out of certain programs, such as temporary protected status and other humanitarian parole programs like the Cuban, Haitian, Nicaragua, and Venezuela program. And what happens with that is essentially these individuals have employment authorization or had it through these programs, and they're abruptly being phased out. There's litigation, and so in one moment these individuals have employment authorization, the next moment they don't. Employers are confused. They're like, what do I do? Does this person have to be terminated now? Or what are we supposed to do? So one of the things obviously is conducting internal I-9 audits, ensuring that you're in touch with Immigration Counsel if you have one-off questions, because there's a lot of nuances that perhaps, E-Verify is not going to capture, or,
Right.
you may not see that. So those are like the high level, really important, I guess, effects of some of these executive orders that employers are facing and that we're getting questions about every day.
Great. Well, I'm sure you could go on probably for
Yeah.
an entire hour on those issues. So thank you for at least kind of level setting, give us a kind of an initial overview of that. I think we are going to get into a little bit more detail. But so everybody knows this, we are going to have our first CLE code. So I'm just going to get it out of the way. The first code, and again, if we could also put it in the chat, code number 1 for CLE purposes is 92154. Again, first code is 92154. So I believe that'll be placed in the chat, and write it down, and we'll proceed. All right. Thank you very much, Cynthia. Alex, I kind of want to turn to you a little bit in light of what Cynthia just really discussed, and kind of the substance of some of these executive orders. I imagine it's probably safe to say that kind of no industry is immune from these executive orders. But I also suspect there's probably some industries that are more impacted by these executive orders than others. So could you provide a little bit of context as to kind of what industries are currently or expected to be impacted by these executive orders?
Yeah, absolutely. I think that's a good way to put it. There are some where there's certainly more scrutiny on particular industries. We're seeing a lot more scrutiny on industries that have a high proportion of unskilled workers, jobs that are traditionally blue-collar jobs, that the American workforce hasn't necessarily wanted to fill those jobs, so employers look elsewhere. So we're talking things, like manufacturing, potentially some line workers. We're talking about construction jobs, things where people are really working with their hands. We see it a lot in the hospitality and restaurant space, particularly with, back of the house workers, dishwashers, line cooks, things like that. We certainly see it a lot in the agricultural and farming spaces, where we get a lot of migrant workers that come with a whole host of legal issues in that sector as well. So generally speaking, it's these kind of blue collar, unskilled jobs. We're not seeing it as much in the office professional setting. And when I say unskilled jobs, I do want to distinguish. We're not talking necessarily about kind of H-1B programs that recruit highly skilled workers. That's kind of a separate animal. But here we're talking about kind of the blue collar jobs that Americans don't want to fill. We're also seeing it particularly in the higher ed space with students. That's not really the employment context, so it doesn't really fall in our wheelhouse. But I know that's something that our higher ed team has been dealing with a lot.
Great. Awesome. Thank you. And I guess at a high level then, and this is kind of piggybacking on what Cynthia just talked about, in what ways are these kind of executive orders impacting the workplace?
Yeah, so I think it sort of depends on whether you're talking about direct enforcement impacts or whether you're talking about more kind of rippling effects. Cynthia touched on some of the main direct impacts. We're talking about things like ICE raids, I-9 audits by government agencies like ICE or Homeland Security. Those types of kind of emergent things that someone would call up their immigration counsel like Cynthia for to deal with that can be kind of alarming to employers. But we also see things that are more kind of side effects that fall within the employment context, these rippling effects, because we have all of this patchwork of federal and state anti-discrimination laws, various laws about how employers have to conduct themselves with respect to hiring and firing and terms and conditions of employment. So when you start talking about immigration and national origin, all these things kind of play together.
Got it. So hiring and firing, either lawful or unlawful. So I guess maybe talk a little bit about that. In what ways can this interplay with whether a company is lawfully or unlawfully, I guess, hiring or firing a particular employee?
Well, anytime that you're talking about immigration by its very nature, you're talking about something that's a protected class, right? You're talking about someone's origin status, their country of origin, which under Title VII, the main federal anti-discrimination law, it is a protected class. Cynthia mentioned that it's also, discrimination is protected under immigration law as well. So just by its very nature, we're talking about something that is a protected class. So it certainly gives way to a lot of interplay with respect to hiring and firing and other employment decisions. And in fact, the Equal Employment Opportunity Commission, the EEOC, this year came out with some, I would call it guidance. It was a press release that was more of a statement so much as guidance, where the acting chair of the EEOC provided this press release that in essence, the title was Protecting American Workers from Anti-American Bias, something to that effect, where she outlined that protecting American workers from anti-American bias is one of her main priorities in her role. So it clearly shows her and the EEOC's current perspective towards immigration and the workforce. And it talked about a variety of reasons that employers might look to hire foreign workers, talked about potentially lower costs or a perception that they're more easy to manipulate, customer preference. And she said, despite all of these reasons, it's my priority to protect American workers. And in fact, the timing was interesting because right around the same time that the EEOC released that press release, it also announced a settlement and some ongoing litigation that I think is really relevant to this question. It was a lawsuit that the EEOC had initiated against a hotel chain in Guam, filed under Title VII, alleging that this hotel chain showed a bias towards Japanese workers. Essentially that they were giving better terms and conditions and were hiring more Japanese workers as opposed to American workers. And right around the time of this press release, the EEOC announced that it had settled this litigation, that the hotel chain was going to pay $1.5 million as part of the settlement, and also some injunctive relief as well. So that kind of provides a very concrete example of how this can play out for employers and how the Federal Employment Agency is tackling these things.
Interesting. Well, thanks. I guess this is the important question then is for the audience. I mean, do you have any recommendations to employers to avoid running afoul of these issues, and specifically kind of the issues related to the case you just cited, or the settlement, shall we say, and the recent EEOC announcement you just talked about?
Yeah, well, first and foremost, and it goes, it should go without saying, is that every single employer, without exception, should have a written anti-discrimination policy and a written equal employment opportunity, or EEO policy. That should be in an employee handbook that is distributed to each and every employee, for which you should get a signed acknowledgement and put in their personnel file. And again, that applies across the board full stop. Every single employer needs to have one of those, because that's the very first thing that the EEOC is going to ask for if they're investigating a charge of discrimination. They're going to say, where's your policy on this? And it's a very simple way to create evidence in the employer's favor, showing, hey, we have a policy, we enforce the laws, and we expect everyone to comply with it. So that's step one. Make sure you have a written policy and make sure that it's actually being distributed and you're getting sign-offs from your employees. But it's also a good idea to just take a general audit of your hiring process, of your onboarding process, because you might have a sense of what steps go into bringing on new talent or what steps should go into it. But until you really go through that process step by step and really take stock of what forms are being filled out, what do our job posts look like, what does our application look like, what are our interview questions, all of these steps that go into hiring someone new, you really want to get your arms around it so you can identify if there are any parts of those of that process that is going to run you afoul of this new perspective of the administration. Go through and also audit personnel files. Like I said, each of them should have a signed handbook acknowledgement. Cynthia mentioned I-9 audits. You want to or I-9 raids. You want to make sure that you are self-auditing your I-9s to make sure that you've got eligibility for all of your employees. But from a high level, just make sure you're treating everyone fairly. That's ultimately what the law comes down to, is that you're not showing bias towards or against any particular workers on the basis of a protected class.
Right. Thank you. Yeah. I mean, there's a lot to unpack there, but I think he boiled it down nicely towards the end. Easier said than done when you have many different, what I'd like to say, supervisors engaging in different interview techniques and different interests. So, all right. Thank you, Alex. Terry, I'm not going to avoid you. So you are next. So Alex mentioned, I think earlier, that these new executive orders will likely increase the chance of ICE raids, right? There's a little bit of a distinction between I-9 audits and ICE raids. We'll get into that later. I know from our conversations that you've actually been involved in a number of these ICE raids in the past. So I want to talk a little bit about that particular issue with you. Initially, are these ICE raids currently, sort of occurring, or are they just anticipated? Meaning, is this kind of an overreaction, or is this like a reality at this point?
Well, I think it's a little bit of both. And like so much else in this area, wait 5 minutes and it'll change, right? But so far, for the first approximate quarter of 2025, ICE has only reported on its website 9 worksite raids and a series of arrests, which when I looked at it, I found to be rather surprising given all of the high profile occurring on the news and social media and everywhere else about people being, arrested and deported. But most of those are not in connection specifically with a workplace raid. But yes, there have been some. And as was noted earlier, there were some general contractors that were hit. There was a tire store and a car wash and a meat market that were hit. All that kind of in industries that tend to employ blue collar, probably quite a heavy presence of Hispanic workers. And interestingly enough, in one of the raids down in Mississippi, the 18 that were arrested were employees that were trying to flee, running out the back of the building, and ICE was there to grab them. So,
okay, all right.
So yeah, they're happening, and I think there might be more, but there may also be some kind of new twists to what's happening in this area. For example, in California, it was recently reported that while it wasn't specifically a work site raid, there were ICE agents stationed along roads in the agricultural area where it was anticipated that agricultural workers would be traveling. And as they, drove by, ICE stopped them and started making some arrests. And you know, so I think we're waiting, we're holding our breath. But
Okay.
you know, wait 5 minutes.
Yeah, no, it's probably, and I guess then, you know, a little bit's happening and maybe more is anticipated. So it kind of leads me into the next inquiry, which is there really anything that employers can or should do to prepare for an ICE raid? Let's say they are in that, the sort of the industries that you just mentioned or that Alex mentioned earlier. Is there anything they can do, best practices is what they can do to kind of prepare for it before ICE actually even shows up?
Yeah, absolutely. You know, if you're the subject of an ICE raid, it is traumatic to employees who are directly impacted, but also to the rest of your workplace and your operations. And so I think you need to approach it as an employer with two major things in mind. One, minimizing your liability, of course. But two, planning for the continued operation of your business. Because if employees get rounded up, if business records and computers get taken, it can almost put you out of business. And I've had at least one client that almost went out of business as a result of an ICE raid. So yes, you definitely want to do some advanced planning and preparation. And in this regard, I'm going to ask people to take a look at the program materials because the PowerPoints do have quite a bit more detailed information. But think ahead. Understand that the ICE agents, probably supported by police, certainly in full regalia, armed, and most likely with aerial support in the form of a helicopter, will come in unannounced. And they will seal off exits and escape routes. They've got to come in through the front door typically. And so that's the first thing to think about is who's going to be their first point of contact. And I'm going to talk about that in a minute and how you can plan for that. They will most likely come with some kind of a warrant. We'll talk about the differences in the kind of warrant that they might come with. They might do things like demand to go into the manufacturing area of your organization, especially if it's something like a manufacturing facility. We'll talk about that in a minute. They can demand to talk to employees. They can demand to see documents. And the documents that they may demand to see, depending on the kind of warrant that they have, obviously can include your I-9s, but it can also include business records. And if you're not prepared for that, they can seize your computers and things like that.
Right.
And that is really extremely disruptive. So in terms of some specific pointers, first of all, in planning ahead, you want to clearly identify public and private areas of your workplace because members of the public can come into a public area. They don't need a warrant. And so ICE agents don't need a warrant to come into your public area. But if you clearly designate and have signage up for private areas, you can prevent them from going into those areas unless they have a search warrant that indicates that is
Right.
something that they can do. You're going to want to keep your I-9s organized and separate, possibly, and think about how you want to do that for your operations. But maybe current employees alphabetized and keeping terminated employees separated in different files. Plan and train your employees to how to interact with ICE agents. Designate a point person who knows how to deal with them, what they can and cannot do, and what you want that person to do like right away, like notify management, call your immigration attorney.
Sure.
Don't answer their questions. You don't have to, if you open a door to a private area, you've given permission, even if you're just the receptionist.
Real quickly though, and just really quickly on this issue, what are your thoughts on kind of employee, like know your right discussions or seminars or training? Advising your employees beforehand to say, hey, these are your rights. I think you mentioned them. Any pros or cons on that really quickly?
Yeah, I mean, I don't think the employer necessarily wants to be put in the position of giving legal advice to their employees. There's certainly a lot of immigration attorneys out there and legal organizations that can provide that information. Whether you want to have somebody come to the facility and offer it as a program to your employees or not. But you don't want to try to hide employees or help them escape. You know, you don't want to encourage them to separate into groups based on their immigration status, which is kind of a tactic that ICE has used in the past. So, you know, there's know your rights cards that you can give out. You can post things. And whether you want to do that or not, I think is up to, you know, to every employer how
Sure.
deeply they want to get into that.
Okay. Well, so that actually gets to the next. So there's things that you can do to prepare, and I know there's a lot in the materials related to that.
Right.
So let's assume, you know, you've done all that, right? And then you have the helicopter overhead. You have 10 ICE agents showing up on the front and the back. Is there any kind of best practices that employers can undertake if ICE does show up to the workplace? And let's kind of assume that they have a judicial warrant of some nature, or maybe that's an issue that you need to explore. What are kind of some best practices in your experience, Terry?
Sure. Well, first of all, hopefully by this time you've been persuaded that you need to have a plan. So think about your plan. You've done your training, you've got your plan. Try to keep everybody as calm as possible and follow the plan that you've developed. So the point person is going to want to examine what kind of warrant the ICE agents have. And there's basically two kinds. There's a search and seizure warrant that's a criminal warrant, and it's going to be dated and signed by a judge and identify specific things, a specific time frame, a specific description of the premises, and what can be searched and seized. There's also something called an administrative warrant, which is a non-criminal warrant, usually signed by an ICE agent, and it's not legally enforceable. Without a judicial warrant, the one I talked about first, signed by a judge, ICE agents can be treated like any other member of the public, including being asked to leave. So, I mean, again, I'm going to ask people to take a look at the materials because I really tried to give a lot of pointers in the materials. You don't want to engage in activities that would indicate or suggest that you're trying to harbor or obstruct justice. You don't want to hide employees or help employees get out or give false or misleading information or heavens, you don't want to be caught shredding documents, okay? But you do want to quickly assess what is going on. You want to, just like any other kind of important thing that goes on in the workplace, you want to have a couple of people follow each agent and document what's going on. Who do they talk to? What is said? What documents do they review? Do they take anything? If they do, you want to make sure that you understand what they're taking. You ask for copies of it. You know, try to get them in and out as quickly as possible, really, because it is very traumatic and very stressful. And then you want to try to figure out how you're going to, and this part should be part of your plan in advance, how are you going to keep your operation running? Your employees are going to be terrified. They're going to be traumatized. And you may have a lot of people who have work authorizations who just don't want to come to work for a while because they're so scared. So, you know, there's a lot of things that you can do to advance plan. The more you can do in advance, the better off you're going to be.
Right. Well, thank you very much. Yeah, and I definitely want you to reference. There's a lot of content in there about how to address these issues. So I appreciate it, Terry. So Cynthia, back to you. Hope you haven't fallen asleep yet. Alex mentioned I-9s, audits, and employee verification. So we've actually, I think we've all talked about them. We've all dealt with these issues. Just real quickly, there's obviously a big difference between an I-9 audit and an ICE raid that Terry just talked about. So can you just, from a high level, just talk a little bit about those differences and how it impacts employers?
Sure, absolutely. And in the materials, we also have a nice chart with a lot of detail there. So hopefully that's helpful for all of you. But generally, an I-9 audit is really a formal review of the I-9s and ensuring compliance with IRCA, which is one of the laws I described earlier. And so how does this happen? Essentially, you'll receive what's called the notice of inspection, an NOI, and you're provided time, so at least 3 business days to produce these records. It's really focused on the documents, right? The I-9s and the supporting documents, not immediate arrest. It's not about going in and finding individuals. And essentially, the result is that if you're in violation, there will be a civil penalty, right? So I don't want to say it's not as scary. It's still something that could, right, potentially be not good for the employer. However, there's a lot more control and preparation you can do for that versus an ICE raid, as Terry mentioned, is usually not announced. It involves, enforcement, a different area of ICE, and then, of course, arrests, seizures, potentially detention, and does require a federal judicial warrant signed by a judge. And so essentially, those are the main differences for the most part. But the idea is, how do you prepare for the I-9 audit, right?
Mhm.
And one of the
Right.
things that I always say is really making sure that you're conducting that internal I-9 audit. For the most part, I know HR teams, they're on it, they know what they're doing, but I think during a time like now, it's more important to get immigration and counsel involved as well, really just to ensure everything is clean, right? And compliant, especially during this time. And like I mentioned, I-9 audits generally can, they're more formal. They can be random though. They can also be targeted. There could be a tip, right? A lead. We don't know, but you do have some time to prepare, obtaining the documents.
Okay.
And so the civil penalties are also something important to be aware of, and we include that in the materials. And then, of course, there's no impact immediately on the employee, right? If something is found out. So in that sense, it's a little less dramatic than a raid, right? So you do have an opportunity to basically address the discrepancy if there's any. You may have to re-verify, or unfortunately, if in cases where you're unable to resolve the issue, there may be a situation where you have to terminate. And there you work with immigration counsel just to ensure
Mhm.
that it's correct. And then, we're also confirming that is, the right course of action.
Got it.
And so really the advice here is to be proactive, right?
Okay.
Just like with the ICE raids, you do want to have a plan, as Terry mentioned, right? Kind of like an ICE response protocol. That's something that we advise employers on and help, right? So implementing a policy, and then even like kind of like a checklist of how do I quickly reference what I need to do if this ICE raid happens. And then compared to the I-9 audit, the preparation would be conducting an internal I-9 audit just to ensure that everything is in order.
And just on that internal I-9 audit that you recommend, is there any like kind of best ways to do that? Is it simply just taking a look at them and making sure the information is correct and on them, or verifying it? What kind of real quickly are kind of best practices as it relates to that?
Sure. So you want to look at all active and terminated employees for errors, anything that had been omitted, or if there's like an outdated form. And of course, correct any errors using DHS guidelines, right? Guidance, and, to be able to correct that. I think sometimes there's some confusion on how to do that, or what if I've never done them and now I'm here, what do I do? So that's important, right? There could be a situation where there was a period of time where they weren't done and then they were done after. So really taking a look at everything,
Okay.
comprehensive review of the I-9s. And so there's, of course, best practices there. You want to make sure that, your I-9s are stored separately from personnel files, and then that you're retaining the records for the requisite period of time, that you're, like I said, using the correct version of the form. Sometimes that happens, and that it's consistent throughout all the locations, and providing training to your HR staff. So depending if you're gonna work with Immigration Counsel on this I-9 audit, just maybe it's just the HR director, and then they train the staff, or sometimes we're involved in the training as well. So it's really depends on what works for your culture, right? And but determining what would be best for your team is important.
Well, this kind of leads to one other, I know, an important issue that I've come across, but I have some clients, this I-9 issue. I've had some clients that use E-Verify. Others choose not to. I've also read a lot in the news about states proposing and passing legislation mandating the use of E-Verify by employers. So I guess the question I have is, just quickly, what is E-Verify and kind of what are its benefits and maybe drawbacks? If you had a minute or a couple minutes to talk about that.
Absolutely. Yeah, it's tied into this as well, right? It's part of that compliance component that IRCA requires. And so E-Verify is an online system that's operated by the DHS in connection with the Social Security Administration. And it basically allows any employers that are enrolled in the program to confirm whether these new hires are authorized to work in the US electronically. So in theory, it's something that, could make my life a lot easier. And in fact, some states like Florida, Texas, Arizona, it's mandated, right, for certain employers, specifically, government contractors or employers that are over, let's say in Florida, I believe it's over 25. And so that's something to keep in mind. So benefits, right? It's quick, right? So immediate confirmation for the most part in many cases. And so it can reduce the risk of really, hiring someone that's not authorized to work. And essentially, if there is an ICE audit and you are enrolled in E-Verify, it shows a good faith effort by the employer to comply, right? So it's a good defense, and it may, mitigate some of the penalties involved if you have any, right? And so that's helpful to know. And then, of course, like I mentioned, for some federal contractors are required to have E-Verify. And so that's just something that if you're in that area, if you have a lot of, clients that are federal contractors, you may want to just do it anyway. So drawbacks, right? So as with any online system, I find there's a risk of error, right? Mismatches. We've heard about this. And then I know some years ago it was something where we were getting a lot of, I guess, especially Social Security mismatches. I believe that was a big one. And so, and it became very frustrating, right? And especially it came up in the context of individuals where, like, for example, it could be their name, their date of birth, where they were a resident and then they applied for naturalization and they changed their last name, or there was an error, a mix up with date of birth, because in some countries they use, the date before the month so there's just a lot of different things that could happen there. And then it then creates more work, right, for the employer. It's like, well, I thought I signed up for this online system and now I'm getting mismatches. So
Right.
that's an issue. And then really it's not a substitute for I-9s. You still have to do the I-9 still,
Okay.
and retain the records. So it almost feels like more work in a way for employers. And then of course, state by state, there may be some specific requirements. And then, of course, administrative burden, you have to train your staff. So you're training them for I-9s. Now you're training them for a new system that's online. So it's just something where you have to think about, is it really a benefit or not? I would think that at least the new administration is inclined to encourage employers to do this, to comply with E-Verify or to enroll. It's not something that's a federal mandate at all at this point, but anything can happen, right?
Okay.
So it's something to consider if it makes sense for your organization.
Wonderful. Well, thank you very much. A lot to unpack and think about there, including the duplicative work that might be created internally. For everyone that's still on, I got the second CLE code. So listen up, and we'll also put this in the chat. Code number 2, CLE code number 2 is 73802. Again, 73802. So again, if we could just place that in the chat for a little while, that would be great. Please write that down. All right, Alex, now on to you, or back to you, shall we say. I've read in the last, getting ready for this and over the last month or so, the Department of Labor stating that they're going to vigorously enforce its authority to investigate H-1B program violations, including cases of discrimination against U.S. workers, kind of this America First perspective. So I guess, do you have any recommendations for employers if you have an immigration program and you're seeking out H-1B employees, perhaps because you just can't find the talent here? Maybe you have not a policy, but kind of an effect of hiring many employees from one particular country because that's where the skill set comes from. Do you have any thoughts about best practices in light of kind of the current administration's perspective on this?
Yeah, I think that's a great question, a difficult question, given some of the issues that you raised, some of the issues we've talked about today, and kind of ties back into, what I mentioned before, that EEOC announcement, which kind of reflects, what you're saying, that America First perspective from the broader administration. So first, I think it's important to distinguish when you're talking about H-1B programs, we're not talking about those necessarily blue collar, unskilled workers that we've been talking about most of this seminar. Now we're talking more about applicants and workers with potentially very particular skill sets. So talking about employers that need to fill a very specific talent gap, oftentimes someone that is highly skilled. And the risk that they run is that they could become akin to that example that I said earlier, that litigation with the hotel chain in Guam, where they end up with a bunch of employees from a particular country, and then a federal agency like the EEOC says, hey, you're favoring a particular national origin. So that's, I think, the risk and what you're asking here. So how do employers protect against that? I think the key is to make sure that you don't have tunnel vision on a specific country. If you're going to look outside the U.S. workforce to fill a talent gap, you want to be able to show a few things if it's ever under the microscope. You want to show one that talent, that skill that you're looking for, it's a real job necessity. You want that to be something you can prove, that it's documented, that it's in the job description, that is an actual bona fide job necessity. But more importantly, I think you want to show that you made some effort to look in the U.S., not necessarily first, but as part of your larger search. So either you looked in the US, you couldn't find the right talent, so then you looked outside the US, or in your talent search, you're looking globally, not just in one particular country. You're looking, wherever it might be in Europe, in Asia, but also including the US in that talent search, to show that you're not discriminating against US workers based on their national origin of being American.
Thank you, Alex. And that's great. And actually, I just noticed a question that came in, which actually I was going to move to Terry next, and I think this actually relates to the topic that you came up with. So we're going a little bit out of tune here, but I do want to address this question. And the question is, what type of signage do you recommend to identify a private area? And obviously, this goes back to the ascertaining up front in preparation what's a private area and what's a public area for purposes of an ICE raid or an ICE inspection. So, Terry, do you have any thoughts on that?
A nice big sign that says "Private, do not enter," or "Private, employees only." Big, obvious.
Got it. Now, I can assume that might imagine if you have number of different work sites, or for example, I'm curious, and this is kind of put you on the spot, what if you're, at a construction site, you're a construction company and it's not actually your property? I don't know. It's kind of an interesting issue as you think about this workplaces that we live in. It's very different depending on what your industry is. So I didn't know if you had any thoughts about that, but I think
even on a work site, you're not going to want members of the public wandering onto a construction site,
Right.
getting injured,
Right.
stealing stuff. So you're going to have signage that says, do
Yeah.
not enter, contractors only, private, something.
Yeah.
and make it nice and big and nice and obvious.
Yeah, I could definitely see safety issues in that. No, that's great advice. Thank you very much. Now, Terry, I'm going to stay on you because I do want to kind of come up with a specific situation that actually came up in my world recently, you know, with a client of mine. But do you have any like thoughts or recommendations what employers should do if they determine after hiring, you know, an employee that they're really not authorized to work in the United States? Obviously, there's situations where they might say, "Hey, I'm not here." I with everything going on with deportations, with things along those lines, I can see this issue becoming more and more prevalent where there might be some either admission or evidence that they're not authorized to work. And so do you have any, I don't know, best practices or steps that employers should at least initially look at if that becomes apparent that they're not here legally?
Yeah, so just like Alex mentioned earlier, employers are kind of walking that fine line between not discriminating, because the law says you can't discriminate, but yet enforcing and implementing their obligations with respect to immigration. So I think the big question is going to be very fact specific, Jason.
Yeah.
What kind of evidence do you have that the employee really is not currently authorized to work in the United States? I mean, at the one extreme, you have an employee who comes to you and says, I just want to let you know, I am not currently authorized to work in the United States. Okay, that's kind of a hard stop, okay?
Right.
But a lot of times what you get are changes in names, changes in identifying underlying documents, innuendos or tips from third parties, maybe an employee of yours who has a grudge against another employee and wants to turn them in. So I think it really does depend on what your kind of evidence you have. And I think as Cynthia had indicated, it's really a good idea to, in those sticky situations, consult with immigration counsel to decide if, I mean, it may be that, for example, they didn't keep their documentation up to date, but they applied. And as we said earlier, there's going to be a lot of delays with all of the layoffs and everything going on. So maybe their documentation expired, but they timely filed an application to renew it. They may be authorized to have an extension of up to 540 days to continue working legally in the United States. So really, it's just going to be very, very fact specific. And it's a tough situation for employers because they are kind of, walking a narrow line.
Yeah, it's a typical lawyer answer. It depends. But I appreciate it, and I appreciate
it is.
because it's.
I gave one example of a hard stop. Okay?
Yes, which probably rarely happens. But all right, so Cynthia, back to you. Kind of going around the horn here. We've talked a lot about sort of different issues, right? We've talked about hiring, firing. We've talked about ICE raids. We've talked about other stuff. I've been reading and I think this impacts employers as well, but I'm reading a lot recently about the revocation or elimination of certain immigration programs like the temporary protected status programs. And you think if that happens, that might have a significant impact on employers who may or may not, who may have some or many employees within those programs. So maybe you could spend a couple minutes talking about what those temporary protected status, what are they, and what to do if we learn of a revocation or an anticipated revocation of one of these programs of which your employees are part of.
Sure. Thanks, Jason. And this is evolving very quickly, just like everything else here. But, generally there's an impact on employment authorization for various programs, TPS, and another one called the Cuba, Haiti, Nicaragua, Venezuela program, also known as CHNV. And, these individuals, for the most part, not all, but they're blue collar workers sometimes, right? They're taking up positions that are maybe healthcare workers, hospitality workers, right? And what's happening is the moment that this designation, right, is taken away, let's say in the situation of temporary protected status, it's not a visa, it's not necessarily legal immigration status. It's actually called an authorized period of stay. So you're here in the US under this protection that is typically temporary. In some cases, for certain countries that are designated, there's over 20 countries that are designated. Certain countries have been designated for years and years and years simply because their country, there's something still going on, let's say in Haiti, Afghanistan, Venezuela is another one. And so what's been going on is essentially the designation has ended for some of these countries. Haiti is one of them. Venezuela is one. I'll talk about Venezuela specifically because what happened there is that there was a lawsuit, right? And so, and actually on March 31st, there was, a stay on this revocation of the temporary for the TPS for Venezuelans in the US. So 1 second they were set to lose employment authorization as of April 7th, and then now they're back on because of the stay. So it's something that, yes, it's evolving, but it's evolving a lot faster in some cases because of this litigation. Obviously, this is subject to change. There can be a subsequent appeal, and it's not a final decision, if you will. But for now, these individuals have employment authorization until April 2nd, 2026. While legal proceedings are continuing. And so that's just an example of how it's important to keep tabs on what's going on with respect to litigation in some of these, and there will be others. As countries lose their designation, I'm sure there will be other legal challenges there. And so just keep in touch with your immigration counsel about that. Another one is like I mentioned, the Cuba, Haiti, Nicaragua, Venezuela parole program. That's a humanitarian parole program that was introduced by the Biden administration a couple of years ago, where individuals were allowed to be paroled into the US. Essentially, they were outside, allowed to enter the US, paroled, meaning like temporarily, but there wasn't necessarily a plan in place to keep them here longer. It was just a program to let them in and provide work authorization. And so, of course, this program also concluded or phased out, but there was a lawsuit, and it was also the end of the program was stayed as of April 14th. So earlier this week. So I had clients asking me last week, are these employees employment authorized or not? And actually now they are. They were set to lose their status on April 24th, next week. So this is very fluid and also very time sensitive. So it's important again to stay on top of it. And those are some of the programs that we're seeing where there's employment authorization impacts, and then CBIS terminations, which we've heard on the news for students. The CBIS program is under ICE, and it's what essentially identifies whether or not students are here legally. And so any students or students who have graduated from their program and are doing occupational practical training, they have employment authorization and maybe work somewhere. And if they're terminated, it's an immediate loss of employment authorization, no grace period. It's from one day to another. So also important to keep in mind. Yeah.
All right, well, great. Well, we have, looks like 2 minutes left based on when we started. And there is one question that actually I think, Cynthia, might be in your wheelhouse. So I'll throw it to you. But we've got a questioner who says that they have cross-border business from Canada, where they leverage certain Canadian employees through TN and L1 visas to support US projects. Have there been any indication of upcoming executive orders or otherwise that may impact those visa types, if you know?
Sure. Thankfully, nothing specific other than what I mentioned earlier regarding delays. The TN program, for the most part, you can either process at the airport, that hasn't changed, or you can go to a border and process there. That hasn't changed, and it hasn't been impacted, thankfully. And with respect to L1s, there are still processing cases. Normally, you can do premium processing, and interviews do not seem to be impacted as of yet. However, as time goes on and these increased vetting requirements are implemented by the agencies, things could change.
Great. Well, thank you very much. We do not currently have any more questions. So, and we're actually right at the top of the hour. So on behalf of Saul Ewing, I'd like to thank everyone, our presenters, for this great material and information, the attendees for their participation. I believe we are adding or have already added the survey link to the chat box. But remember to keep an eye out for the email with all the goodies, the information, the materials, the links, as well as the continuing legal education verification survey that you're going to need to report the codes from today's webinar. And if we didn't get to your question, we will. And if you have any other questions that have come up after this, or if you've looked at the materials and you just have a follow-up question, you can always send a question to me or any of the presenters. You know, we just really appreciate your attendance, and thank you very much for your time today.